Tonight on the Daily Debrief, a verdict against an accused cop killer. He says his trial was unfair. Plus, the infamous El Chapo in court to be tried on charges related to his alleged drug cartel. And the defense prepares for its final day in the case of a man accused of murder over the death of his infant. That's straight ahead on the Daily Debrief for Monday, November 5th. And good evening, everybody. Welcome to the Daily Debrief. Let's go straight to Memphis, Tennessee tonight, where jurors delivered guilty verdicts on Sunday, a rare weekend verdict against Tremaine Wilburn. Just as this trial was beginning, Wilburn pleaded guilty to the lesser charges there, carjacking and firearms charges. That left jurors to decide whether he was guilty of the top count, murder, and they agreed that he was. Now, this case involves the death of Officer Sean Bolton. Prosecutors say Wilburn pulled the trigger 8 times to stop Officer Bolton from arresting him. The penalty phase of this case is now underway, and that is where jurors must decide whether Wilburn should face life in prison or be sentenced to death. Wilburn himself interrupted that phase of the case this afternoon to complain that he did not receive a fair trial. Here's his back and forth with the judge over whether he would allow his attorneys to present evidence that could keep him off death row.
I've been getting a fair trial. I feel that nothing that we presented to the court has been used. Like everything has been rejected. I gave a plea. They took the plea back. It's just saying I don't have states that they have to receive certain things that I wasn't aware of. So I don't feel like if my lawyers, we have a miscommunication about certain things. So I just feel as if we can forego mediation, I can be sentenced. So I want to continue
Ms. Wilburn, I don't have any control over the states indicating that they would consider allowing you to plead life without the possibility of parole. They told you that would be contingent upon the family acceptance of that. Do you understand that?
It is just one issue.
Okay, that's one issue, but I have no control over that. Do you understand that?
Yeah.
I can't tell the state to allow you to plead anything. I have no control over that. Do you understand that?
Yeah.
Now, Mr. Gangula, Ms. Pastor, Ms. Hall have prepared mitigation for you. And when you say you want to forego all of this, Mr. Wilburn, that's 100% your decision. Do you understand that, sir?
Yes.
If you tell the court that you do not want your lawyers to present mitigation evidence, that is your choice. You have absolute control of that decision because that's a factual decision that you are allowed to make. You understand that? It would not be in your best interest, Mr. Wilburn, to tell your attorneys that I do not want you to present any mitigation. That would not be in your best interest. You understand that, sir?
Yes.
Joining us now for perspective on this is attorney Matthew Mangino from Pittsburgh. How are you tonight, Matthew?
Good. How about you, Aaron?
I'm well. The judge is sitting there saying, look, I can't give you legal advice, Mr. Defendant, but you're teeing yourself up for complete and utter failure. He probably should listen to the judge on this one.
Oh, no question he should listen to the judge. His outburst, so to speak, that he's not getting a fair trial, that everybody's failed him in the system, certainly if the jury were sitting there would not endear him to the jury. But to say I don't want to present any evidence, including any mitigation evidence, would certainly be a direct line to death row.
Exactly. Look, I mean, the state has to present these aggravating factors. The defense gets to present the mitigation. And if he says, I don't want the mitigation presented, what does the jury have to go with? All the aggravators. We're going to continue on with our analysis of this case now. The first of several prosecution witnesses in this penalty phase was the victim's brother himself.
The night of August 1st, 2015, I, like everybody else, heard about the death of my brother via the news media. They put the wrong name, the wrong age, the wrong marital status, that he had children when he didn't, and it was on the TV, and that's how we all thought maybe it wasn't him. It couldn't be him because they had the wrong name. And my mother was a nurse at the time, and she was in a patient's room, and she was preparing to place an IV. And she looked up, and the patient had the TV on the news, and she looked up and saw a picture of her son saying that he had been murdered. And she hasn't been able to go back to work since. She tried, and she couldn't. She can't work.
Next up, the defendant's probation officer testified about the defendant's criminal record.
He was convicted of armed bank robbery and carrying a firearm during and in relation to a crime of violence.
And are those crimes of violence to a person?
Yes, they are.
And what are the underlying facts of those convictions that you would tell the ladies who come on the jury?
The underlying facts were that Mr. Wilborn and I believe it was a Mr. Mackey went into a Friendship Bank in Covington, Tennessee around June of 2005, and they were wearing masks and they were both armed with firearms. And I believe Mr. Wilborn's actually had the people in the bank lie down on the floor while Mr. Mackey took the money from the teller station. Then they both left the bank and their car would not start, and so they fled on foot until they were apprehended.
Tremaine Wilborn's pastor testified today that Wilborn came from a troubled neighborhood and about helping the defendant himself turn himself into police after a manhunt.
I saw him on TV, and I told my wife, I know the guy, and she says, yeah. So she saw the look in my eye. I said, let me see if I can get him to turn himself in. So the next day, I went into the neighborhood to one of the car washes there, and I inquired. I said, if you know where Tremaine is, have him to give me a call. And I told him, hey, I need you to meet me at the church. Well, this is what I told the young guys who called. Tell him to meet me at the church. He said, I want you to meet me at my grandmother's. I said, no. I said, I think the other people would know where your grandmother lives too. Meet me at the church. So once we went to the church, we decided we won't even meet in the neighborhood. We gave him a designated place to meet us. He said, I didn't want to turn myself in to the police. I want to go to the U.S. Marshal.
Now, earlier on in this case, one witness from the crime scene testified that he tried to call 911 but could not get through. So he picked up the officer's radio to summon for help.
Hello? 364 Delta. Y'all got a man down. Where? Okay. 72 on Summer Lane, man. Hurry up, you bleed, man. Bad, man.
You recognize the person that was saying that?
Me? Please hurry up.
Who was that?
Me? 4870. Summer Lane. 48 Summer Lane. He's shot. Officer, he's shot.
How long was it before someone responded after you got on that radio?
About 2 or 3 minutes.
When you saw the officer, you said you saw a hole in his shoulder.
Yes, sir.
And he was face down with his hand in his face. Did you happen to observe his weapon?
In the holster.
What did you say?
It was in the holster.
Okay, but it wasn't out.
No.
Matthew Mangino is back with us now. Matthew, look, let's talk about this. Testimony about a defendant's prior bad acts oftentimes really puts off a jury.
Oh, it certainly does. I mean, you know, this is a man who's been convicted of murdering a police officer, and now we're going to hear historically that this, you know, isn't his first encounter with violence, whether it was on the street or in institutions. He has a long history of violence, which is indicative of being violent in the future and, you know, dangerousness. So those are very important factors for the jury to weigh during the penalty phase of a death penalty case.
Now, you had a pastor testifying about this guy coming from a troubled neighborhood. You also had a defense expert saying that this defendant's father died in a car accident, so he basically didn't know his father. Said his mother was a drug-addicted hooker. Jurors could take some of that and weigh it against the aggravating factors that the state has presented.
Well, that's their responsibility. They have to listen to determine if the state has proven the aggravating circumstances beyond a reasonable doubt, and they have to weigh those with the mitigating factors that are presented. And here, the mitigating factors were compelling. I mean, he had a terrible childhood. His mother was a prostitute. By the age of 7, she's reporting him to the police as being incorrigible. He has a history of mental health problems, depression, post-traumatic stress disorder. He reached out for help from his probation officer because of his mental health only months before the murder. So some of that evidence was compelling.
Certainly. Matt, we're going to check in with you again at the end of the show here. Still ahead tonight, though, on the debrief, the case of an Iowa man accused of murder over the death of his infant son, and jury selection in the federal prosecution of accused drug lord El Chapo. He escaped from a Mexican prison to land in U.S. federal court. That's when we return on the Daily Debrief. Jury selection began today in the criminal trial against an accused drug lord. Joaquin Guzman, better known as El Chapo, faces federal charges in the United States. Security is extremely tight around the U.S. courthouse in Brooklyn today, and the Brooklyn Bridge was shut down to securely transport the defendant to court. El Chapo faces 17 criminal charges involving drug trafficking and allegations that he murdered his rivals. Federal authorities think he smuggled some 200 tons of cocaine into the United States. Joining us tonight to talk about the criminal case against El Chapo is defense attorney Ross Kramer. Ross, this defendant escaped from a prison in Mexico in July 2015. So do the security measures here in New York surrounding this trial make light in relation to that?
Well, look, it's a balancing act. You have to balance the security of the jurors alongside the prejudice that comes with having jury selection with an anonymous jury, with a sequestered jury, where there's extra security, where there are jurors being transported back and forth from the courthouse by federal personnel. It sends a very dangerous message to these jurors that this is a person who is suspected of, violent crimes here. But at the same time, this is someone who's accused to have been involved in witness tampering and witness murders in the past. So you really have to balance one against the other.
You've got a really high-profile defendant here, a high-profile case. What pressures does that put on the prosecution?
I mean, it's tremendous. They really want to win this case. This is one of the largest drug trafficking cases in history. This is the biggest drug trafficking organization in the world. Those are the accusations. And certainly the prosecutors in this case are under a lot of pressure to win this case. They have a lot of evidence. They have a lot of witnesses that the public doesn't know about right now because of security concerns with those witnesses as well.
That's exactly where I was going to go next with this. The names of the witnesses, the names of the jurors are being kept secret. So if the names of the witnesses are secret, then how does the defense properly and adequately cross-examine them?
Well, they're not secret. The names of the witnesses are not going to be secret from the defense. They're secret from the public for right now because of safety concerns. These are people who are being held either in witness protection or in special segregated units at prisons and are going to be transported very securely to the courthouse. So the defense is able to prepare because there's a constitutional guarantee of a fair trial here. But at the same time, the public doesn't need to know that information. And I'm sure there are all types of protective orders making sure that that information doesn't go beyond the need-to-know basis of the attorneys representing the defendant.
Certainly. Now, the defense says these charges are just simply the result of tainted testimony and information from witnesses who are mostly killers and drug dealers themselves. That seems to be the defense tactic thus far. Should we expect that to stay its course, or should we expect another tactic here?
Yeah, I imagine that there's going to be a lot of cross-examination of the prosecution's witnesses. And like so many major federal cases, these are bad guys. These are cooperators who themselves are drug traffickers, are violent criminals. But that's the way that prosecutors have to make these cases in order to bring down sophisticated, large-scale enterprises, the same way that they bring down mafia enterprises.
Federal authorities think El Chapo is worth $14 billion, but his lawyers claim he's struggling to pay his legal bills. Opening statement scheduled next week. This is sure to be an interesting case. Ross Kramer, criminal defense attorney, really appreciate your insight on this one as always.
Always happy to be here.
Time now for a check of other incidents making headlines with Anthony Velez.
Here are today's top crime stories trending on Law&Crime.com and across the country. The young driver accused of striking and killing 3 Girl Scouts and a mother in Wisconsin was reportedly inhaling chemical vapors, also known as huffing, prior to the fatal collision. 21-year-old Colton True was arrested after striking the victims with his pickup truck and fleeing the scene of the deadly accident in Lake Hallie. True later surrendered to authorities and reportedly admitted to huffing chemical vapors before crashing his Ford F-150 into a roadside ditch where the victims were performing a community service project. True now faces 13 charges, including 4 counts of intoxicated use of a motor vehicle. Christopher Watts, the Colorado man accused of killing his pregnant wife and 2 daughters, had his next court date moved up by 2 weeks by prosecutors in Colorado. Watts is accused of killing his wife Shannon and his 2 daughters, 4-year-old Bella and 3-year-old Celeste, in August. Watts now faces multiple felony charges, including 3 counts of first-degree murder and 1 count of first-degree unlawful termination of a pregnancy. A North Carolina woman dubbed South Park Susan after she was caught on camera in the middle of a racist rant to 2 black women as they waited for AAA service was arrested for making 2 calls to 911 deemed a misuse of the emergency line system. 51-year-old Susan Westwood turned herself into police in connection with the October 19th incident.
Nobody cares. I'm white and I'm hot. I'm white and I'm hot.
Westwood was fired from her job at Charter Communications and now faces criminal charges. Those were today's top crime stories. I'm Anthony Velez for the Daily Debrief.
Testimony is on hold until tomorrow in the Iowa murder trial of Zachary Keene. The judge in that southeastern Iowa case sent one juror home for having a so-called meltdown after hearing horrific testimony last week. Keene is accused of a specific subsection of Iowa's first-degree murder law, which covers the death of a child. He's also accused of child endangerment for basically neglecting his 4-month-old son to the point the child died. Keene appeared upset in court during a 911 call where he said his girlfriend checked on the child and found the little boy dead. Later, he covered his face and refused to look at autopsy photos of his dead 4-month-old. The defense tactic here has been to blame the authorities and blame the child's mother, but mostly for the defendant to say he had no clue his child was suffering from neglect. He took the stand to try to convince jurors that is what happened.
Were you at any time in your son's life aware that that was a condition he was in? You knew that he was not being fed, what would you have done?
I would have fed him, for sure.
You knew that he was not being changed, what would you have done?
I would have parked the wastebasket beside me and I would have changed him myself.
And any time is there a reason that you didn't check to see whether he was being changed?
No, I had trusted her judgment. I mean, look at my daughter, she's very healthy, and so I trusted her.
Examination, the defendant basically played dumb about his infant son's condition, but backed away from previous suggestions that his girlfriend was to blame.
Are you saying that Sterling's death is all the fault of Cheyenne Harris?
No.
You're saying that you have some responsibility?
If I would have known, yes, I do.
So you're saying that what you did wrong is you didn't know?
Yes.
You told this jury that you used methamphetamine, right?
That's correct.
But you told them the only reason you did it is to stay awake to work, right?
Yes.
You told this jury that you gave Cheyenne Harris methamphetamines, right?
That's correct.
But the only reason you gave it to her is because she'd become difficult if you didn't, right?
That's correct.
You told this jury that you used your company's credit card without authorization, right?
Yes.
But the only reason you did it is to feed your family, right?
Yes.
You told this jury that you didn't change diapers because you had a weak stomach, right?
That's correct.
And you couldn't handle the smell of feces, right?
Yes.
But you worked at a manure hauling company?
Human feces and animal feces are different in my nose.
Your nose is that refined?
Of course.
Okay, a nose that refined that it can differentiate between human and animal feces. He said that. He said he used credit cards basically for food, and meanwhile his friends were testifying that he was doing drugs. Bottom line, it went downhill from there as the state exposed a number of the defendant's contradictions.
You told this jury that you didn't see Sterling because he was asleep. Is that what you're telling this jury?
Yes.
And you're telling this jury you didn't see Sterling in your apartment because Cheyenne told you not to disturb him, right?
Yes.
You told this jury that you didn't turn the light on in Sterling's room because you didn't want Sterling to squint, right?
That's correct.
So that's why you couldn't see in the room?
You could see a little bit. It was a mild light.
You told this jury that you didn't interact with Sterling in the living room of the apartment because he had a bad smell, right?
No.
A sour smell, you described it. Isn't that what you said?
Yes, but we were headed out on a family get home, so there wasn't much time to interact.
You told this jury the reason you didn't call 911 right away is because you didn't have the cell signal. Is that right?
That is correct.
How many doors did you go knock on asking for a cell phone or asking for help?
None.
Back for more discussion is attorney Matthew Mangino from Pittsburgh. Okay, look, he's dancing all around the state's questions there. Questions about, you know, why didn't you check on your son? Oh, I didn't want to turn the lights on because I didn't want him to squint. Are jurors going to believe this guy or what?
Well, his testimony was incredible. It's hard to believe that he could sit in that chair and someone could have listened to what he was going to say as they prepared for that and let him say it. I mean, he didn't, you know, he couldn't stand, you know, the smell of diarrhea, but obviously he could stand the smell of his 4-month-old rotting, essentially maggot-ridden, sitting in a chair for estimated 9 to 13 days, sitting in a swing. I mean, it's really unbelievable that this defendant could take the witness stand and think that the responses that he gave on cross-examination would somehow enlighten the jury that he's not culpable in the death of his 4-month-old.
I agree with you. Look, I mean, and there's a little 4-month-old child named Sterling who's dead in this. We have a very limited time left, Matthew, but look, we know that the mother of the child, this defendant's girlfriend, is going to go to trial separately, so that will be interesting as well.
Right, and essentially his testimony is, it's not my fault, it's her fault. I worked, you know, I couldn't change a diaper because I couldn't take the smell. I should have, I trusted her and she failed me. And
yeah,
that's not a good defense.
Look, I mean, it's going to be finger pointing, but I think jurors are probably going to see through it. Testimony in that case picks up tomorrow. Matthew Mangino, thanks for joining us tonight. It is all the time we have tonight on the Daily Debrief. A reminder, of course, that the Law and Crime Network will be streaming many of the trials we discuss beginning tomorrow at 9 a.m. From all of us here at Law and Crime, have a good evening.